On the record, in the matter of the people of the state of Michigan versus Brian Johnson, file number 23-00189. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Johnson.
Okay. Johnson, today was the date and the time that was set for a preliminary examination. I have an indication here that there's going to be a waiver to the circuit court. Is that correct?
It is, Your Honor.
Was there an offer extended?
At this time, no, Your Honor. All potential negotiations would need to occur at the court level.
Oh, okay. And so, Johnson, you understand the purpose of the preliminary examination?
Yes.
You have the right to require the prosecutor to meet their burden of establishing probable cause. So they need to put forth evidence to show that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with those crimes. Do you wish to unconditionally waive your right to examination today?
Yes.
Okay. Anybody threatening you to get you to waive the examination?
No.
Any promises being made to you in exchange for a waiver?
No.
You understand that it's unconditional, it's not based on any promises or threats, and you can't change your mind once this matter is bound over, that right is gone forever. You understand that?
Yes.
Bind over date is going to be January 24th. That's the date that the circuit court's going to get the file from the district court, okay? You do not need to appear in court on that date, okay?
Okay.
Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date. You stay in contact with your attorney. You have any questions at this time?
No.
Bond was set at 20,000 personal cognizance. That will continue, as well as a no contact order. Any additional matters for the record?
Yes, Your Honor, just briefly, I would want to just put on the record, the people had previously notified defense, but we will be amending the information to correctly reflect defendant's habitual offender third status. And the PAC code for that is 769.11.
Any additional matters?
No, Your Honor.
Okay.
No, Your Honor, thank you.
Okay, you're all set.
Thank you.
Just saw Mr. Goodrich peek his head in, so I'm gonna see if I can grab him.
I like your haircut.
Oh, you can.
That's why I said I like your haircut.
Well, thank you. Is Goodrich out there?
What?
Is Goodrich out there?
I see just what.
He'll make it.
Oh.
on the record in the matter, the people of the state of Michigan versus James Minor, file number 23-03820. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Stephen A. Freeman, Public Defender, on behalf of Mr. Minor, who's standing to my left.
Okay, how are you, Mr. Minor?
No, go ahead, Richard.
I'm doing well. Today was the date and the time that was reset. Set it for originally for the preliminary examination. I said I would treat it as a probable cause conference. How are we proceeding?
It was my understanding that the defendant was intending to set up for prelim.
Okay, need a prelim date?
Thank you very much, Your Honor. Yes, it's my understanding that the people are not in a position to make any kind of an offer. And so we would like to go forward with the exam at the convenience of the court and clerk.
March 8th at 9. March 8th at 9 a.m.
Thank you.
No problem. Do you have any questions for the court today, sir?
No, ma'am.
Okay, we'll get you a notice to appear. Bond is set at 20,000, 10%. That will continue, as well as a no contact order for an Alexa Minor. Any additional matters for today's record?
Nothing from the people, Your Honor. Thank you.
Nothing for the defense.
Thank you. You're all set.
Thank you.
Oh, they had to come back. I didn't wait the 21 days.
Oh,
I got you. I'm sorry, you good.
Back on the record in the matter versus James Minor, I was just reminded I never addressed the 21 days on this. So this matter was originally scheduled for preliminary examination today. You have the right to have your preliminary examination within 21 days of the date that you're arraigned. However, and I'm not sure what the delay was it delay in the appointment or
May it
was
please
it?
the court?
Yes,
The gentleman originally at arraignment indicated that to the magistrate that he was going to represent himself. And so there was a delay in terms of the public defender office getting sufficient information and so forth. I myself just got this file yesterday afternoon about 3:30. So if there's a delay, it's chargeable to the defendant.
I get it. Okay, so I will note that in the file. That's why I didn't know which, your name wasn't on here originally. That makes sense. So you just got the file. Basically.
The appearance will be later today. Thank you.
Okay, sounds good. And so, Mr. Minor, you recognize your right to have a preliminary examination within 21 days of your arraignment? Okay, and due to your late request for a public defender, are you willing to waive that timeline so that we can reset this to March 8th? Okay, and no one's threatening you to do that?
No, no,
Nobody's promising you to get you to waive the timeline?
no, no.
Okay, you're all set.
Thanks again. Your
Thank you.
Thank you.
yep. As soon as your appearance is filed, then our office will be all over this.
Okay, let's see. I saw Mr. Goodrich and then I didn't see him again. Mr. Nichols probably not ready yet. It's a little early. Is he running an exam or he's covering for Hess? Is that what it is?
Well, it's now, he's taking over for,
Oh,
Hess,
okay.
'cause I don't believe Hess with disciplinary offset anymore.
I didn't know that. Okay,
Yeah, I don't think it's likely that, Potter will be running.
okay.
I obviously can't speak for certain. And then
What about Barney?
Barney, I think I just saw Ms. Schroeder with, the defendant. So,
Okay,
I need to,
Chambers is in custody. Okay, sounds good.
and then James.
I don't know why they gave it to another judge, but they did.
Well, on the record in the matter of the people of the state of Michigan versus John Edmund Sherman Jr., file number 23-03161, council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, on behalf of Mr. Sherman, who stands to my left.
How are you, Mr. Sherman?
I'm doing all right.
Okay, today was the date and the time set for preliminary examination in this matter. And we're not proceeding, is that correct?
Your Honor, the people were planning on proceeding and finishing today with Officer Donovan Moore. It is my understanding from speaking to other officers of the Lansing Police Department that he is still on administrative leave, but that should be ending within the next week or so. The email that I gotten back in December about it said that he was going to be off administrative leave by the end of December, which is why I didn't believe it was going to be an issue. But because of the holidays, it looks like it got bumped a little bit. So because of that, I would be asking for an adjournment. 21 days in this case has already been waived due to, if I remember correctly, there was both waiting for the old case to be reissued, as well as there was an issue with discovery and the public defender's appearance. For some reason, it got delayed, so we did not get it until that morning of the previous examination date. That's why I was adjourned last time. But 20 days has already been waived in this matter.
Okay, and the old case that was reissued, is that the one that you're
Yes.
having today? Okay.
That was when we initially signed off on in 2021, and it fell into one of the COVID cracks where it just never physically went to the judge to get sworn to.
Okay, sounds good. Mr. Freeman.
Thank you very much, Your Honor. At the pleasure of the court, I have no dispute with the comments offered by Mr. Pfeiffer. They're factually correct. If the officer's on administrative leave, my only concern was when he might be able to return, but that certainly sounds like a good cause to me.
Okay, yeah, we've already waived the timeline. The officer is on leave. There's really outside of anybody's control. And you said he should be back on duty when?
The comments I got from the other officers, I think it was particularly Officer Slovin, was that it should be done within the next week or two. But I am going to also call the actual LPD higher up chain of command to try and get a better estimate on it.
Okay, that's fine, because our next date won't be until probably March, I think.
March 8th at 9:30.
March 8th at 9:30.
Okay, perfect. I don't think that's going to be an issue. I will call LPD higher chain of command, and if for some reason I'm hearing that it will, I will let the court know immediately.
Okay, sounds good. Any additional matters for today's record?
Not from the people, Your Honor.
Nothing for the defense. Thank you.
Ron will continue, as well as the no contact order. You're all set for today.
It's a different job.
Oh, okay, sounds good. Sounds good.
I'm gonna go run down there.
It's still not, we're not gonna run a prelim today because officers, everything, so
Oh, okay.
we're gonna either, she's gonna talk to them too.
Sorry. Sure.
Barney is here. Chambers is in custody. What happened with Mr. Mandulano?
He's about to move.
Oh, okay. There he goes. On the record, in the matter of the people of the state of Michigan versus Jose Manduhanu, file number 21-02270 FY, council appearance.
Good morning, Your Honor. Robert Ianni, Special Assistant Attorney General on behalf of the people, license code IANNI.
Good morning, Your Honor. Reina Diaz, appearing on behalf of defendant Jose Mandan. He 80239.
Okay, thank you. Today was the date and the time set for preliminary examination. I had these documents in my files. I'm not sure who sent them.
Those will be discussed during the hearing.
Okay, not exhibits?
No, they're not exhibits, they're just references for the court.
Okay, sounds
One
good.
from me, one from you.
Okay, and do we have preliminary matters that we need to address before you can call your witnesses?
See, Gunner.
Your Honor, I do have a issue, a prelim issue. One of the documents, the Uniform Interstate Family Support Act that's before you is something that I'd like the court to take notice, judicial notice, that that is the law that would apply for personal jurisdiction over a non-resident defendant. So I'd like that to be noticed by the court, that that would be the law that governs whether or not there's personal jurisdiction over the defendant in this case, pursuant to section 2 of the statute of failure, the support statute that were here before. Section 2 requires that that you cannot bring the felony unless the court in which the court order had personal jurisdiction. And personal jurisdiction is governed by the statute that's before your honor.
Today, you want to respond?
Yes, Your Honor. The only issue before this court in terms of jurisdiction for the crime committed in Michigan, within the county of Ingham, City of Lansing. The question, one of the issues, one of the elements, I should say, of the crime that the defendant was aware of the underlying case. Was it the case I gave to the court, the Iannucci case, that set out the elements of the crime? 314, which is 542. On page 1 of what I provided to you, the court says the elements of the criminal offense are simply that it was acquired by divorce order to support a child, who appeared in or received notice of that action, the action in which the order was issued, and failed to pay. Those are the elements we have to deal with. Whether the statute that you were provided has to do with the jurisdiction of the underlying family court over the defendant.
Agreed.
So we're gonna, obviously we have to prove one of our elements is that he was aware of this underlying action. Whether that court had jurisdiction in the first place is a collateral issue which has to be taken up in family court.
Agreed.
Not at this time. We will, through our testimony, prove he was aware of that action, failed to pay child support. As far as we're concerned, he committed a crime in the state of Michigan, county of Ingham.
Your Honor, may I respond quickly? I would like to say that would render section 2 of the felony support statute then useless and moot, because it states that this section does not apply unless the court in which the support order had personal jurisdiction It does not state, and it refers to how personal jurisdiction, and it defines it specifically over a non-resident defendant. If legislature did not intend for this section to exist, then they wouldn't have put it there. So I asked the court to consider why section 2 is there, then mandating that personal jurisdiction be a factor. And if it's not there, then they cannot bring a felony charge.
You're talking about section 2 of the Uniform Interstate Family?
No, Your Honor.
Okay.
But in section 2 of MCL 750165, the statute under which this felony charge was brought.
Well, as the Attorney General indicated, it's part of the elements that he needs to establish. He's got to establish that the person had knowledge or was aware. This act that you provided, and I'm assuming you provided this is not what controls a criminal act in the state of Michigan.
No, Your Honor, I'm just saying that I'm using that for going off the statute that's before us, that my client is charged under. Section 2 of that statute that's before us states that you can't bring this felony charge unless, so it says that this does not apply unless the court had personal jurisdiction. So it specifically states personal jurisdiction in the statute that the people are bringing. So in that statute, it states it under. So that would render that moot if that's not applied. So I asked that that's also an element that needs to be proved, that section 2 of the felony support statute requires a finding by the court of personal jurisdiction. And that's why I provided the Uniform Interstate Family Support Act, which states how personal jurisdiction is found. And those are the elements that one of those elements must be proved for personal jurisdiction.
Any further argument on that?
I know, Your Honor, as I've stated, that the elements are for this crime are set out in case law and in as well as statute. Attacking the underlying order itself has to be done because we can take certain notices that certain things were done. We have to assume those are all correct. I will present as part of our evidence the underlying certified copies of the court documents, and that's what we're going to go about.
Thank you. I agree. Your motion is most appropriately taken at the circuit court. This is a preliminary examination, and we deal with probable cause, and that's the standard here for today. So, not that I believe you made any motions. I think you just asked me to take notice taken, and any motions that you want consistent with this argument that you've made are most appropriately addressed at the circuit court. You can call your first.
Yes, John.
witness.
So we're going to call City on Burns. She believes she's waiting outside. If you don't mind, I'll go get her and
No problem.
bring her in with the court officer. You mind if the front of the court officer sits next to me?
I have no.
Okay.
Concern.
You're in the witness box. I'm sorry.
I was gonna say, which one's the witness?
Don't sit in my, don't sit in my place.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. Please make sure your cell phone is off.
Mr. Full, state your full name for the record, please. And where do you reside? Are you familiar with the defendant in this case, Mr. Jose Manuel Manduano?
Yes.
And you see him in the courtroom? Point him up for the record. The record should reflect that he's identified our defendant. How do you know Mr. Manduano?
Any objection to identification?
Excuse me, hold on.
Any identification? Okay, objection. No objection. Identification is noted. You can.
Thank you, Your Honor. How do you know Mr. Manduano?
He's the father of my 3 oldest kids,
And how old are your children?
13, 12, and 10.
And at the time that, have you ever lived with Mr. Manduano?
Yes.
When was it?
During the time we had kids, which was years ago.
Well, approximately.
So anywhere from 2000 and 2015,
Where did you reside?
multiple places. Texas, Ohio, Michigan,
Where were the kids born?
in Ohio.
All 3?
Yes.
You were residing with Mr. Manduano in Ohio at the time children were born.
Yes.
There come a time when you moved to Michigan.
Yes.
I want you to describe for us what the events leading up to your move to Michigan.
So we lived in Ohio. My youngest son, he was a newborn baby. We moved to Ohio because, we moved from Ohio because we got evicted. And we went to stay at my aunt's house. Jose came with me, he stayed there for maybe a month, and then he went back, but I stayed.
Okay, so you were living in Ohio and you got evicted?
Mhm.
Is that a yes?
Yes,
Yes.
sorry,
And when you were evicted, you had no place to live?
correct.
So where did you decide you were going to live?
My aunt said that we can come and stay with her, so we went to stay with my aunt.
And where was this house located?
In Hunter's Ridge in Lansing, Michigan.
Lansing, Michigan. Did Mr. Manduano come with you at that time?
Yes, he did.
Did you have any other place to live at that time?
No,
Was it your intent, at least at that time, to stay in Michigan indefinitely?
yes.
And how long did you stay here?
I,
Excuse me, how long, you stay here ever since? I think. How long did Mr. Manduano stay here?
maybe a month,
And why did he leave?
he wasn't happy here, he left. I don't know the exact reason.
But he lived with you for about a month.
Mhm.
Is that a yes?
Yes, sorry.
And how did you come to apply for child support in this case?
I had applied for food stamps and Medicaid. And at one point, they said that I was not cooperating with child support because I did not give his information. So at the time, I had to report that he was the father of my kids, and it became that the state put him on child support.
Did you have any meetings with a friend of the court's office at that time?
Yes, we did.
Was there any effort to contact Mr. Monduano?
Yes.
Describe those efforts for us.
So we had a meeting scheduled. His was going to be,
Let's put it in a time frame.
Oh,
Approximately.
it was in 2014 when the case was first established. When I first came back here, we had a meeting scheduled for him to do it virtually because he lived in Texas or Ohio. I don't really know at the time, but he ended up telling me that he didn't make it because he ended up going to jail. So the child support was established without him
All right, how do you know that he was aware of that meeting?
because I talked to him.
Then he didn't show up for the meeting?
Correct.
And then after that, what happened?
He said he had went to jail, and after that, it was nothing but arguments about him being on child support.
Was a petition filed to establish child
Yes.
support?
Is that a yes?
Yeah.
Let me show you what's marked as People's Proposed Exhibit 1. Can you just identify that document? Is
Complaint for child support.
that is the petition that was filed?
Yes.
And then I would move that People's Exhibit 1 be admitted.
Any objections to
Certified
people?
copy,
No
she's
objection.
identified it.
One's admitted without objection.
And let me show you what's marked as People's Exhibit 2. Court documents. And can you just identify that document?
It's a child support recommendation.
That's part of your petition.
Yes.
Ask that People's Proposed Exhibit 2 also, it's a certified copy, also be admitted.
Any objection?
No objection.
Equals two is admitted.
Show you People's Proposed Exhibit 3. Just identify that.
Uniform child support order.
And that's also part of the filing in your case.
Yes.
I would ask that People's Proposed Exhibit 3 be admitted, Your Honor.
No objection.
Equals three is admitted.
And finally, let me show you a document that's marked as People's Proposed Exhibit 4. What is that?
It's a judgment order.
And it's also in your case?
Yes.
Is that Exhibit 4 be admitted?
Any objection?
No.
Equals four is admitted.
After the order of child support was established, did there ever come in a time when that order of child support was discussed between you and Mr. Monduano?
Multiple times.
And can you describe some of the context?
Some of it was through text messages. Most of it was arguments because he didn't want to be on child support.
Did there ever come a time when child support was taken from his pay that you were aware of?
Yes. Sometime around in 2017.
And describe the conversation you had with Mr. Monduano concerning the withholding from his pay.
When it first was established, that he was getting money taken out of his checks, he told me that he had a job in Ohio. He was working for the union or something, and it was expecting out of his check. And then he told me that he quit his job because he did not like how much money they were taking out of his check.
All right, between the period of, and this was the dates in the complaint, between the period of January 1, 2016 and August 31, 2018, did you receive any payments from Mr. Monduano?
Yeah, I can't say the exact amount, but every once in a while he would do something.
Approximately, maybe?
He bought shoes for kids before. He's most recently in June of this year, he sent $250 for summer clothes.
The child support order That's part of what the exhibits, I believe it's $738 a month.
Mhm, yes.
Did you receive $738 a month from him during that time?
No, I have not.
I believe the total, there at that time frame is 32 months. The math is correct, it's around $23,000. Have you received anything near $23,000 from him during that
No.
time frame? I have no further questions of this.
Cross-examination, yes.
Okay, Ms. Savion, you stated that you and Jose lived in Michigan for a while. What year was that?
2013.
And because you were evicted from your home
Apartment in Ohio.
in Ohio. And then did Jose have a job in Michigan?
No.
Did he have, if you know, did he apply for a driver's license in
No.
Michigan? Was he looking for work in Michigan?
No,
So do you know what his plan was in
he
Michigan?
didn't want to be here. He ended up leaving.
So you agree that he did not come to Michigan with the intention to stay in Michigan?
No, I do not agree with that because he did come to Michigan with intent to stay. He was not happy. He was arguing all the time. He left.
But isn't the reason you came to Michigan was because you were
correct.
evicted?
Yeah, correct.
So it wasn't planned or anything?
Well, actually, we did plan. We could have stayed in Ohio, but we chose not to.
And who did you stay with in Michigan?
My aunt.
And is that the address 5708 Hughes?
No, we lived in Hunter's Ridge.
And that was 2013?
Yeah.
And then since 2013, did you go back to Ohio?
Yeah.
And when did you go back to Ohio?
I went back to Ohio a few months after that. I went to Cincinnati and stayed with him.
You and the children went back to Ohio?
Yes,
And how long did you stay in Ohio?
like maybe 2 months because we ended up getting evicted there too. And I went and stayed in a shelter in Columbus.
And that was 2013?
That was in 2013 and 14.
Okay, and then after that, where did you move?
I moved back to Michigan, and then after that, I moved to Texas.
When did you move to Michigan after that?
So it would have been in that same year, around 2014, 15. Because right after that, I moved to Texas. I wasn't here very long. I was on and off back and forth with him.
In 2015, you moved back to Texas
Yes.
to live with Jose, correct?
No, I did not go to live with him. I moved there on my own, and then he moved there after his brother passed away, and then we ended up getting an apartment together.
So you did live together
Yes,
in Texas?
yes, we did.
Okay, and was that the address 206 Pioneer Parkway?
I don't remember the address.
Would you use, and this, I'm referring to exhibit 1 that you were shown, which is the petition for the initial one. And the address, you provided the address to the prosecutor's office to where Jose was, right?
Years ago, when we first established the child support, but that was when I first moved back here. I don't remember that exact address to this day. I don't remember.
But the address you provided at that time, why did you provide, what address?
Because
did you
I was
provide?
told that I needed to provide information on my kids' father in order for, since I was not cooperating at first. When I got the order saying that my case would be closed if I didn't cooperate with child support, I gave them any information that I had.
But the information you gave, the address, I'm saying, the address that you
Right.
gave.
That
So
was
how,
years ago. I don't remember what that.
but how did
was.
you know that was his address?
Because I lived there with him.
So you had lived there with him and you gave them the address that
Yes.
you guys were living.
Correct.
Okay, and so in June 2015, you were living in Michigan, correct?
That's correct.
In April 2015, were you living in Michigan?
No, I was in Texas.
Okay.
Actually, no, I'm sorry. I moved from Texas in February, right before my son's birthday.
You moved from Texas in
In February.
February 2015,
15, yes,
and you came to Michigan.
that's correct.
Okay, and then have you been back
No,
to Texas
no,
or?
I've been in Michigan since.
Okay, and I'm going to refer you to exhibit 4, which is the judgment itself. The address that was provided in the judgment, or that was how the address for Jose was a different address than the one that was in the initial.
So I don't have any addresses for him. The only one I gave them was from when I first got on child support. All the information that they have on him, they got that information themselves.
Okay, so you don't know whether or not Miss Jose received the judgment or.
Only thing I have is communication with him that he basically confirmed he knew he was on child support. That's all I know. I don't know anything about what he received or anything like that. I can only go by what we talked about.
You told him that there was a judgment?
No, he told me. He told me he received something about making payment arrangements. It's in the text messages. I gave them the text messages. Something that he received something about making payment arrangements for the back pay that he owes. It became a whole argument between me and him because he wanted to be taken off of child support completely. I told him I have no control over that, but if he gave me something in writing that he would help take care of his kids, then I would do what I can. But that turned into a whole argument too, so I blocked him. I don't have any communication with him anymore.
You said it was about back pay,
That's correct.
but at that time, there was no back pay because the judgment was.
I'm
just
talking about our
entered.
most recent conversation we had in June this year.
I'm talking about the 2015.
I don't know what
Judgment.
he received then. I only know what he received from what he told me. I don't know anything about what he received when he got it. I don't know anything about any of that.
So do you know that your conversation, those text messages and conversations you said you had with him, was that for the 2015 judgment when it first got entered? Is that when you?
He didn't tell me. He just said that he received something offering him to make payment arrangements. That's all he told me.
And was that in 2015?
No, that was just this year.
Okay, so in 2015, did you have any conversation or messages that he received the support order?
No.
So you don't know if he received the support
Right,
order?
which is what I said. I don't know.
Also, you're familiar with Jose's family, correct?
That's correct.
And the address, 2006 Pioneer Parkway, Arlington, Texas, that was where the initial case, the complaint was sent to.
I do not know.
Do you know Jose's father?
I do.
What is Jose's father's name?
Okay.
Jose what?
Manuel.
Okay, and do you know his middle name by any chance?
Manuel.
Jose Manuel Mandujano.
Yes.
Isn't that also the defendant's name, Jose Manuel Mandujano?
Yes.
And did you know that that address that you gave to the friend of the court?
Mhm.
Did you know who was living in that house?
No, all I know is the address that I gave them is where me and Jose live. His dad didn't live with us then, so why would I give them his dad's address?
So you gave them the address where you guys were living to
Yes.
start the case?
That's correct.
Okay, so that address, as far as you know, Jose was living there only.
Right, he lived with me and our kids.
But when you left,
I don't know who lived there when I left.
do you have any, do you know Jose's mother?
Yes, I do.
Do you know where she was living?
She was living in Greenville.
Okay, and have you had any contact with her?
Yes, I talk to her all the time.
Okay, and did she tell you anything about signing the, that she received
No, she did
the
not.
complaint?
No,
And did she tell you, does she send you money?
yes, she does.
How often does she send you money?
Just recently she sent me something for Christmas. Every now and then she'll send something for one of the kids' birthday
And why does she send you money?
because her son doesn't take care of his kids.
And do you know where she currently is right now?
She's in prison.
Do you know for what?
Yes, I do. I'd rather not say.
Do you know that if it's for,
Your Honor, objection, this is totally irrelevant.
What's the relevance? Objection sustained. You don't have to answer that.
you stated that you lived in Arlington, Texas for a while.
Mhm.
That's a
And,
yes, correct?
Yeah,
Thank you.
okay, and 718 Deerfield Circle, Arlington, Texas. That was what you had stated in the verified statement. That is, I'm referring to the People's Exhibit 1, the complaint for support. Second last page.
You want her to see it?
Second last page. I can. Do you want to- Yes. So in the verified statement, so this is what you had first applied for the support, correct? That's the information you provided to the friend of the court.
Okay.
And do you see under Jose's name, can you read the mailing address that you provided?
718 South Deerfield Circle.
And if you go back to on the same document, page 3. On that return card, can you read the address that was provided here?
206 West Pioneer Parkway.
Okay, so these are two different addresses, correct?
And that's also not my handwriting either. So I couldn't have provided that.
Just answer the question.
Yes, two different addresses.
Which address was correct?
I don't remember. I have not lived there in over 10 years. I don't know.
Okay, so but the information you gave in the verified
All of
statement
the
at the time
information that I
was
gave
true.
was
at the
correct,
time.
yes.
Let her ask the
Correct.
question.
Yes.
So if you had given 70718 Deerfield Circle, Arlington, Texas, at that time, that answer would have been true.
Yes, it would have.
Okay, so would you agree then if that at that time, if something was mailed or sent to to Jose to a different address,
He still would have received it. Either way. Both addresses. Trust me, when I lived there, we bounced from house to house while I was living there too. His mom, his grandma's, his mom, his aunt, his own apartment. Every address that was provided for Texas is because I knew it because I stayed there. And so has Jose.
in the verified statement, you only provided one address
Which is the one that I lived at with Jose.
in Arlington, Texas.
Yes,
Okay, so you're not sure which address you resided in Texas?
Not-
Because
no,
there
I'm
is
not
one
sure.
in the verified statement, that's 718 Deerfield, which is what you provided to the front of the court. Okay,
yes.
and however, as you can see on page 3 that we just referred to, that complaint was sent to a different address, which is 206 Pioneer Parkway. You agree that that was not, you did not list that address in the verified statement.
No.
Do you know how this address was
I do
provided?
not.
No further questions, Your Honor.
Redirect.
Nothing further, Your Honor.
And this witness be excused.
She can, Your Honor.
Spell your first and last name.
SEYBION, last name BURNS.
Okay, you may be excused, ma'am. Thank you. Call your next witness.
Russell McKenzie, Your Honor.
She walk this way though.
Walking.
Oh, excuse me.
This
Walk
way.
this way.
Go on.
Sorry.
Yeah, just go ahead and sit outside the address.
Okay.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. You can state your first and last name and spell both.
First name is Lowell, Lowell. My middle name is Russell, which is the name I typically go by. My father and I share the same first name, Your Honor. Russell. My last name is McKenzie, McKenzie.
You can proceed, counsel.
Okay, Mr. McKenzie, where are you currently employed?
I'm currently employed at 30th Circuit Court for Ingham County. I'm a signed friend of the court as a court services officer.
And how long have you been so employed?
Almost 10 years.
In the course of your employment, are you familiar with the case file involving the defendant's case, Jose Manuel Manuano?
Yes,
You had a chance to review that file?
yes.
Based on your review of the file, can you tell us what the current arrearage is, Mr. Manuel?
A little over $75,680. I think it's 7,000 or 75,681 and like 60 cents.
Thank you. Let me show you what's been marked as people's proposed exhibit 5. Can you identify that document?
This is a payment history taken from the Michigan Child Support Enforcement Systems in the state of Michigan, which is a database jointly developed by all 50 states and federal government.
And that's a document that's kept in the ordinary course of business.
Yes.
And it's a certified copy that you have in your hands?
Yes, sir.
All right, Your Honor, I move that people's proposed exhibit 5 be introduced.
Any objection?
Your Honor, I object as to relevance because we're talking about 116 as the date, so I think these dates are in 2018, so I don't know what we're trying to establish.
Did you want to respond to the
I
objection?
could, Your Honor. The document in question supplements the testimony of the prior witness, that there was a period of time when there was wage withholding being taken out of the defendant's pay, which certainly put him on notice and made him aware, documentary wise, that there was a child support order entered against him.
Objection is overruled.
Thank you, Your Honor.
People's, this is what, 5?
That would be people's 5, Your
This
Honor.
5 is admitted.
I have no further questions for this witness.
Cross-examination.
Mr. McKenzie, you stated that you were in charge of reviewing the file?
I did review this file.
Okay, and have you reviewed the return card on the summons and complaint?
Yes, ma'am.
And do you agree that the box is checked as agent instead of addressee of the defendant? And do you agree that personal service usually is to the addressee restricted and not to an agent?
Typically it is,
So,
unless there's been some prior arrangement, and I am not aware of any prior arrangement. You could have some, or would have somebody else sign for it.
this was by an agent. If this was checked and you saw this, did you see this check? Or did you just notice it right now when I brought it up?
I saw it checked before, but I didn't have anything to do with the signing or the sending of that document.
So according to you, the summons and complaint to initiate a case in Michigan, it's okay for an agent to receive for service of the pleading.
It actually doesn't even have to be sent certified. In the state of Michigan, civil process can be done by first class mail.
For an initial complaint and
Yes.
summons?
I just need some clarification. You're on the exhibit 1, correct?
Yes.
And when you're saying there's a check, you're talking about where the signature is here?
Yes.
Yours looks different than mine, but
Can I,
is yours redacted? Is that why?
Perhaps the yellow.
Oh, hers just
Cover-
looks darker than mine.
Yes, it might have covered the
Okay.
agent. There's a little check mark.
These were copies of.
Because I don't see a check mark at all. So that's why I want to make sure I'm not missing something. I
I
can't
have to
tell.
see what she's.
I can't tell. It looks like a signature that's just written over, but I don't know. I don't see that either one is actually checked because it looks like a scribble in between both of them on mine.
and that's what we have, Your Honor. We were provided this. I don't have the actual green card, but they do. That's why I was asking if it was reviewed, but if there was a check mark on agent, so, because front of the court would have the
I
green
can't
card.
tell. It almost looks like the signature goes over both boxes.
That's what it looks like for me.
Agent and addressee.
Okay, however, you just stated that if it was an agent, it still would have been sufficient service of the pleading, correct?
Yes.
I would like to defense says proposed exhibit, we're going by letters, right? A?
Yeah.
Yes, you and me.
Wanted to show you this. That driver's license right there of Jose. And the signature on the bottom, which is of the certified cards. The return map.
Okay.
You see, are those two signatures?
Your Honor, before he testifies as a substance of it, you have to introduce.
Correct, I thought you were trying to lay a foundation, but I'm not even sure how he would be able to lay the foundation for this exhibit. He doesn't know what this is. You told him what it was, which is testimony.
Yeah, sorry, because the bottom one was introduced already into evidence, which is the green card, the certified return card that we just talked about. So I'm
Right.
showing him that. So that was already admitted into evidence.
Okay, I'm confused then what is that then? A photocopy of the,
Of my
that.
client's ID,
His driver's license.
his driver's license.
okay, you created this document?
Yes,
Okay, and you want him to testify as to it?
yes, I just want him to look at it and just and see the signatures.
Okay, we would have to have that admitted first.
Okay, so well, I just want, can I just verify that he sees that this is the green card that was signed?
You can see that it's a green card.
Okay.
It probably, I mean, did you blow, let me, is it blown up? I'm not sure. Did you show it to him? Did you
Yes,
show it to him?
this was provided to the prosecution last week.
Okay, because we have it here. Why can't we just use this without putting them on the same page? We have one admitted already.
Yes. So on the green card,
Well, you can't ask him about the green card. It's not in evidence yet.
what is?
Well, the green card is on
Oh, they were
this.
talking about that green.
Yeah,
card.
that's
Yes,
the green card.
the return receipt. You got it.
The return receipt. Okay. So the date of delivery on that was June 9, 2015, according to this. The judge, and I'm going to refer now to exhibit, the people's exhibit.
It's one.
Are you looking at the judgment?
The one where I was reading. Yeah.
That's this one.
Are you looking for the one with the return?
The
card?
one with the verified statement of.
Oh.
Baby on. I believe.
Over here. It's the last page of one,
The last.
second to last page of one.
Sorry, Your Honor, I'm just grabbing the correct exhibit. So this is the prosecution, the people's exhibit 1. The verified statement that was attached to the initial petition complaint that was filed. The verified statement there, was the information on there reviewed by yourself? Okay. And the address for the defendant, for Jose,
Yes.
was that the address that you used to send Jose the complaint?
I didn't use the address because I wasn't employed at the court in that capacity to send this form. I didn't send it.
Well, do you know how how address would be determined then for service?
Addresses are identified in a number of ways. An address frequently is provided by one of the other parties to the case. And if there is mail sent to that address and it is returned, I did not work this case initially, but I had a counterpart. One of our functions in our position is to research and identify other potential addresses for mailing confirmations through the U.S. Postal Service and subsequent mailings to go out. So I didn't come up with this address.
Okay. So the address that was provided by Ms. Sabian was not used by friend of the court to mail or to reach Jose.
At least not on this particular document, no.
Was it used for any documents, do you know?
I would have to go back through the rest of the file. There were a number of addresses, both for her and Mandahano. It appeared that both parties changed addresses more frequently than I have.
The mailing address that Sabian provided the court was on Deerfield, on Deerfield, so Deerfield Street. However, the summons and complaint was served to Pioneer Parkway in fact.
It is possible that the other investigator found an address for associated with Mr. Mandahano and that mailing was sent to her. But I did not, and that other investigator retired some years ago.
Okay, and you heard Ms. Sabian testify that she did not provide the address that was on the return receipt.
I did hear that.
Okay, and do you then, the judgment, People's Exhibit well, I'm gonna go with Exhibit 3 first, the Uniform Child Support Order. Could you please read the address that the support order was sent to for Jose?
South Deerfield Circle, Arlington, Texas, 76015.
Okay, and do you agree that that's a different address than the one that's on the return receipt? Okay, and in fact, that's this address that Sabian provided in her verified statement.
Yeah.
Okay, so do you know why a different address was used to mail the uniform support order than the one on the return receipt?
In this case, I don't know why. I wasn't a party to that.
Okay, so would you? I'm going to go to Exhibit 4 now, which is the judgment and order entered July 17th. I'm sorry, August 25th, 2015. Could you please tell me the address that this was sent to defendant? In fact, if you look on the first page, do you see that defendant's address is not listed?
It does not list, but it also doesn't list an address for Ms. Burns either.
Would this document have been mailed to defendants?
That document would have been mailed to the defendant and probably, and may well have been sent with a cover page that.
And would it then be the same address that the support order was sent to, the Deerfield address?
I don't have firsthand knowledge of that.
Do you recall the friend of the court show causing Jose for not paying child support?
No.
So there wasn't an order to show cause him?
I was out of state at that point. Everything I had, the addresses I found for him were all in Texas.
Have you ever talked to Jose?
I did not.
Have you ever had any communication other than talking, email, or any
I have
mail?
not. There's not any correspondence in any of the case notes that he's ever reached out or had contact.
And how did you confirm that he received notice of the court order?
for first class mail. And then the green sheet that was signed was certified.
Green sheet is a different address than the support order.
Okay.
How did you determine that this was the correct address?
I did not. I wasn't the investigator on this case.
So there's no way, so there is no assurance that this was in fact where Jose was living, correct?
Which address?
Either one.
No, I was not in Texas. The address, we base the initial mailings off the address were provided
By whom?
by the other party.
Well, the other party provided a different address than what you sent the initial
But
pleadings
the initial address that she provided was one that the order originally sent. I don't know what transpired in between time that resulted in the order. It could have been, that address may well have been located by another investigator.
Have there been any attempts to enforce child support in the family court?
Yes.
What attempt?
When we found out that he had moved and Ms. Burns moved to Florida, Ingham County friend of the court, utilized an interstate transfer of the case for supervision and enforcement, first by Florida in May of 2020. And Florida learned that he had moved to Texas. So Florida transferred the case to the state of Texas for supervision and enforcement somewhere around June of 2021.
So this case was in, Texas had jurisdiction over the support order? And
They had enforcement jurisdiction. This was originally an Ingham County order, so we do not lose administrative control of the order.
you stated that you found out that he had moved. You found out that the parties had moved.
Yes, through my investigation, I learned that both parties had moved from Ohio. Ms. Burns had moved to Florida. Mr. Mondahano had moved to Texas.
Did you know what the address he moved to?
There were at least 3 addresses in Texas that I initially uncovered.
Were there ever any show causes filed?
Texas did nothing for enforcement on this case.
And what did Michigan do besides, before bringing this felony charge? Were there any attempts in the
No,
circuit
because
court?
no, because enforcement at that time, that role had transferred to the state of Texas. Texas was responsible for the civil enforcement and establishing show cause hearings for the case, and they did not.
But why were there no attempts to show cause in the family court before proceeding with a felony charge?
We don't have jurisdiction for doing show cause. When we transfer the civil enforcement to another state, they have operational control of that docket and are responsible for the civil enforcement. We are not.
So you cannot show cause him in the family court here.
Once the enforcement piece has transferred to another state through the interstate process, that other state is obligated by federal law to assume the enforcement responsibilities for civil enforcement and establishment of show cause.
So does the family court then have jurisdiction over this child support order?
Yes, we do. Texas has what is referred to as operational control of the file and the docket for enforcement. We retain administrative control over the file because it was an Ingham County order to begin. So for that file for the order to be modified, Texas would have to come back to Michigan because the signing judge, the judge that is the judge of record for that docket, would be responsible for determining what changes, if any, should be made to the order.
So why were felony charges brought in Michigan, not Texas?
Because Michigan retains administrative control, and this is a criminal offense as opposed to civil. Texas is responsible for the civil enforcement. Michigan retains the ability for criminal prosecution.
Okay, last question. Just want to go back to the first thing we talked about, which is the certified receipt, the green card that initiated the case. So I just want you to tell me if the court has, if this is regular practice that you deem sufficient service of the pleadings and summons by an authorized agent.
If he authorizes somebody to sign certified mail for him, that fits the statute. It would be, the only presumption I could make, it would be similar to me declaring, giving somebody power of attorney or giving them authorization to sign my name. It happens, my father gave me permission to sign his name on his homeowners and vehicle insurance policy because he doesn't have a computer.
Well, do you agree that Michigan law requires that the service of the initial pleading, the summons and complaint be restricted to the addressee and not agent?
I'm not aware of that requirement in state law.
No further questions. John.
Redirect.
I just one question. You said you reviewed the file in this case. There's been multiple correspondence with the defendant, both sending them copies of orders and things of that nature. Anything in the file which indicate that something was returned undelivered? Yes. What was that?
There were all documents that I've got in my stack. There were a number of efforts by our office to identify an address and or an employer. Some of the addresses came back as not deliverable, no forwarding address or not deliverable, inadequate address. And there's at least one document in the court filed regarding employment where the employer reported that Mr. Mandahano had actually left the employment some month or
As far as mailing him the orders, the court orders, any of those come back undeliverable?
not that I'm aware of.
Okay.
May this witness be excused from the stand?
Yes, Your Honor.
Thank you, Mr. McKenzie. You may be excused. Any additional witnesses?
I know, Your Honor.
Is the defense calling witnesses today?
No.
Okay, for proceeding argument.
People move that this case be bound over to circuit court. The elements of this crime have been established as we've indicated. The elements. The defendant is subject to a decree, an order, a legal order of the Michigan Circuit Court, requiring him to pay child support for 3 children residing in Michigan. We believe that the facts have indicated the defendant, every effort was made to make the defendant aware of that case. There was testimony by our first witness, Mr. Burns, that the subject matter of this case was discussed in various conversations. There's also evidence in People's Exhibit 5. The defendant was aware that there was a child support order against him by nature of the fact that there was a wage withholding in it against his paycheck. So we believe that sufficient testimony and evidence has been established to indicate that he had noticed. Every effort was made to get, he was obviously not resident. Every effort was made to make him aware, every reasonable effort was made to make him aware of the case. So all courts are required to do is to give as best notice as possible. Sometimes these things are done by publishing in a newspaper. It used to be done when they had newspapers. So nowadays, anything that the court can conceive of that would give the defendant reasonable notice. He did have notice. He had notice, in fact. And the testimony also shows the third element that he failed to pay. He owes over $70,000. There were some nominal payments that the defendant is receiving, but they didn't amount to about $1,000. Well short of the amount charged. We asked that the case be bound over based on the elements of this crime have been established.
Defense counsel?
Yes, Your Honor, we asked for the discharge of defendant from these charges because contrary to what the people have stated, there was nothing except the fact that no one was sure or certain about the address of the defendant. No one is sure whether or not personal service of the summons and complaint has to be restricted to the person who is receiving it. Due process is not optional, it is mandatory, and that is required by law, that the summons and complaint be served in the proper way. If alternate service by publication, yes, it's there. However, there's procedures to get there. To waive that and to skip that and to say he had notice without the initial step that's protected by this constitution would just be undermining to the rules that are clear in the summons and complaint. You heard the front of the court personnel state that even if it was for an agent, that would have been okay.
That was his testimony. There's no other testimony otherwise that process was not in proportion with the law. That's your argument, there's no evidence otherwise that comports with that. He said that was appropriate for the process.
Correct. I'm saying that even if he states that, the law, as a matter of law, this court should reject that notion, because summons the service on a summons and complaint must adhere to the strict principles that are required. So if that had been the case, then that would have been deficient. So, and as well, you heard the testimony that Savion gave a different address in her verified statement than the address that the complaint and summons were mailed to. And no one is sure if that was received or not. So all of these deficiencies in the case with the due process rights of the defendant, and that's what's at issue. And for the people to act like due process is optional when it is absolutely a requirement, and for this court to ensure, I ask for the court to discharge defendant, because we don't even know, and they don't even know, the people don't even know if the addresses were correct and whether or not he received service of them. Now, for the part where Savion stated that they did talk, the people have brought this charge dating from January 2016. Savion stated that she informed him in 2017 and recently. So at the time what these charges were alleged, it's that time that matters and not after, because that's what we're here for. We're here for the crime allegedly committed on the date of the complaint, which is January 2016.
Through August of 2018.
Ms. Savion stated, we just talked recently. I don't know before. So there is no evidence of that. There is no evidence of my client residing in Michigan. Him being here for 30 days, if that's true, that's not enough to establish residency or intent. Whatever it is, she said they were here because they were evicted. She stated that she moved back to Texas and at that time, and then returned to Michigan. There's no way, and there's nothing introduced to show sufficient evidence that my client had his due process rights, his right for the initial summons and complaint, which is a right of every citizen and every non-citizen under the Constitution to be protected when receiving the initial summons and complaint. For that reason, the highest court of this state has stated that that is sufficient basis to dismiss a case. When service is improper of the summons and complaint, then everything else is flawed in the case. The default judgment of support was entered based on this faulty proof of service. And this is where we are now, stemmed to everything else. My client was in Texas, he was never in Michigan. There is no evidence that there was any credible effort or anything taken to find my client. Friend of the court did not have any concrete answers as to that. And the facts itself showed that there were multiple addresses sent. And what's most concerning is the fact that we have a court officer stating that it's okay for the summons and complaint in Michigan to be served in violation of MCR 2105 and 07, which clearly requires that it's restricted to the addressee. An agent cannot do that. And that is by law, Your Honor. So I ask this court to apply the law as is and protect my client's due process right, and require the friend of the court do their duty and protect my client's due process, because that's not acceptable and shouldn't be accepted by this court. So I ask for the court to discharge defendant and dismiss this case and have the prosecution file their case again if they do have more concrete evidence. Thank you.
Any re-argument?
The only thing I want to just mention, Your Honor, the prosecutor or the Attorney General's office, as this court, we have to take notice of certain things. The fact that there was an order issued by the circuit court, it appears to be valid on its face. These are things we have to just accept. They want to challenge that order, they have to go back to the circuit judge. They want to say that that order was improper, they have to go back there. We have to live by the fact that the order it exists today. It's a matter of fact, it's there. We're trying to enforce the order of the circuit court through the criminal process. Any attack on the legality of that order must be brought before that judge. The only element that we have to show is that he was aware of it. We've done that to numerous testimony and evidence. She says he wasn't a resident of Michigan. He was here, they moved here with an intent to stay here for at least 30 days. Michigan could establish residency, or excuse me, establish jurisdiction with a one-night stand. That's all that's required. There's not a lot required to establish jurisdiction in the state of Michigan, but that's a matter for the circuit court and the family court.
Beyond a brief, can I just respond to that? Just 10 seconds.
Then I gotta let him re-argue.
No, I'm
and
not
we go back and
I'm not
forth.
gonna go.
We don't know what she's
I have
gonna
nothing-
say.
I have
Go ahead.
nothing for.
No, I'm not, we're not challenging it. We're not challenging the order that's in the circuit court. I'm challenging the fact that it's being brought under a felony. The felony statute is what prevents this order from being, from my client being criminally prosecuted for this. So no, it's not something for the circuit court, the family court to address. This is a felony being brought, and my client's rights are, his protections are heightened, and that's why the court in this statute that they're bringing the charges under requires the court has, that this does not apply unless the court had personal jurisdiction. They didn't say when the court serves the summons, they had personal jurisdiction. That choice of words by the legislature is intentional. And it's because the personal jurisdiction statute over non-residents is explicit in stating how service is completed, how personal service is established. One is individual is personally served with citation, summons, or notice within this state. And that is, if we don't apply this and say that it's a, you know, an attack, a collateral attack on the family court issue, that would be deeming this statute irrelevant. Why would it be there? As section 2 if legislature did not intend for this court, the criminal court, to ensure that there was personal jurisdiction. And personal jurisdiction is not the same as proof of service in the circuit court, or else we wouldn't need it in here.
I'm not gonna keep
Nothing
arguing
further?
over this now.
Okay, today was the date and time set for a preliminary examination. The burden is squarely upon the prosecution to establish that they have probable cause sufficient that a crime was committed and probable cause to charge you with the crime. This is not a trial. We don't address the burden of proof of beyond a reasonable doubt. Today is just more than mere suspicion that the crime that was alleged was committed. And so the court will be the sole determiner of any credibility of witnesses, and the court will also weigh the likelihood of the prosecutor's success at the time of trial. And the count 1 here, failure to pay child support, is the only count that we're addressing here. And the criminal jury instruction 34.4 indicates that at the time of trial, the prosecutor would need to prove then beyond a reasonable doubt, first, that there is a court order that requires the defendant to pay child support for his children. Second, that the defendant appeared in or was personally served with notice of the action in which the support was issued. Third, the defendant failed to pay support in the amount or the time stated in the order. We had testimony today first from a Savion Burns, who identified herself as the mother of 3 children with the person she identified in the court as the defendant, Jose Manuel Mandujano. She indicated that the children were being born in Ohio, that at some point they moved to Michigan after living in Ohio because they got evicted, that the defendant, Mr. Mandujano, lived with her. They lived with her aunt at Hunter's Ridge, which is in the city of Lansing. state of Michigan, and that the defendant stayed for about a month, and then he didn't like it here. He moved back to Michigan, back to Ohio, that is. It appears that at some point she returned to Ohio as well. She ultimately moved back to the state of Michigan, and at a certain point around 2013, 2014, she applied for assistance for benefits in the state of Michigan, at which time she was required to tender the information regarding the father of her children. She indicated she wasn't originally cooperative, that eventually when her claims for support or assistance in the state of Michigan would be denied and closed, she did cooperate and provide every information or piece of information that she had as it relates to contact for Mr. Mandujano. She testified that there was a attempt, or he was noticed about an attempt for a meeting in 2014 for a virtual meeting, to which she stated she knew he was aware because she spoke to him about it, and that the defendant failed to show up to that meeting and indicated that he didn't show up because he was in jail. The order was entered without his participation. The people have admitted multiple exhibits. We have People's Exhibit 1 through 4, which indicates in People's 1, there is a complaint for support dated for 2015. And People's, with the coordinating documents and attachments, including a return receipt for registered mail or certified mail. People's Exhibit 2 would be the child support recommendation from 20. I'm trying to locate the date on this matter. From 2015 as well. And then People's Exhibit 3, Uniform Child Support Order, which is also from 2015. And then People's Exhibit 4, a judgment and order that was entered by the 30th Circuit Court back also in 2015 by Judge Laura Baird. And then People's Exhibit 5 being the Michigan Child Support Enforcement System detailed report. In that detailed report, there was, from People's 5, there is reflected at the bottom where there was a wage assignment in 2018 for an amount that was deducted. It looks like there was 1, 2, 3, 4, 5 deductions that was made from Mr. Mandujano's wages, consistent with the order for the court order child support. And People's Exhibit 2, which the defense, I'm sorry, it should be 1. People's Exhibit 1, which the defense has spent a lot of time on, indicating that the return receipt, the section for the card, indicates an address that was to 206 West Pioneer Parkway, number 7, Arlington, Texas. The first witness testified that she provided address where she believed the defendant to reside, because that was the address that she resided with him in Texas. That address not being the same address indicated here in People's Exhibit 1 on the return receipt card for the certified mail. The witness did indicate that there were multiple addresses that they bounced back and forth to while in the state of Texas, but she could not provide testimony as to why or how this address was the one that was selected to be used to deliver the order to Mr. Mandujano. Nor could she attest as to whether or not the signature here was in fact this Mr. Mandujano. because there is another Jose Mandujano, which is the father of this Mandujano. Nonetheless, the signature card indicating a signature and a date of delivery for June 8, 2015, it doesn't, from my look at this document, doesn't indicate one way or the other whether or not agent or addressee was selected, because the signature seems to obscure that. So that creates what we call a question of fact as to whether or not that was sectioned, and the question of fact is addressed by the jury. Also, the court is going to, can infer that the defendant had noticed by multiple things. We had a witness that testified that there was multiple conversations about that with Mr. Mandujano, that she even had conversation with Mr. Mandujano about his appearance, or his notice to appear for a meeting in 2014 to discuss the order, to which he later indicated to her that he didn't come because he was arrested. Also, her indication about multiple conversations regarding the child support order and how he was unhappy with it, and he wanted her to have it terminated. I don't know if he was personally served by registered mail in this, and that he checked it off or not. I also don't know if there was later somewhere in the file a motion and order entered for alternate service. I don't know that. That's again, not an issue for this court. Those are all questions of fact. Do I believe that there's probable cause sufficient as to each element of the charge of failure to pay child support? There is more than sufficient evidence to support probable cause. And for those reasons, count one will be bound over to the circuit court for further prosecution, and your bind over date will be January 24th, 2024. You do not need to appear in court on that day, Mr. Mandujano, okay? That's that a yes?
Yes.
Okay, that's the date the circuit court gets the file from the district court. Your next court date will be a pre-trial, unless for some reason your attorney makes a motion in the circuit court for another arraignment date, okay? And at that time, you'll get your next court date if you don't get another arraignment in circuit court. Do you have any questions for the court at this time?
Is there a pretrial date, and that be established by the
That's-
circuit court?
The circuit court will establish that once they get the file.
I have a question, Your Honor, but it's
Yes.
about if we can discuss the bond.
The bond was set per statute, and so I won't be able to address that amount if that's what you want to address.
Well, I'd like to address the good cost factor, but we have a couple of witnesses here, my client's father and his employer, who's in Texas, who's here.
The defendant's employer?
Yes, the defendant's employer. So the good cause, that exception allows the court to modify its bond, in fact, and even not have any bond, but where my client's family's here, the risk was that he was extradited from Texas. However, it was because he lives in Texas and non-resident of Michigan. So what we ask for, Your Honor, is for the bond to be reduced to $3,000, which is what his family can pay today, to allow him to go to work. And there would be no risk of, unless he doesn't show up, there has been no history of him not showing up or missing a hearing. The extradition is the only thing. And unless this court has, unless there's evidence that he would not show up again, which, Your Honor, I don't think there's anything that would fairly be used against my client, except the fact that he's a defendant in a criminal case. He was extradited on this warrant, on this criminal complaint. So for reducing the bond to allow him to go to work so he can make money and start paying it towards child support. And again, the employer is here, he retained counsel, his father is here. And I believe that it would be in the best interest of the children if he contributes towards a payment instead of staying in jail and doing nothing. And again, his employer is here and can testify if this court would like to hear from him. He has counsel. So we ask for that, Your Honor. And then, with the $3,000 and his commitment to make payments towards child support and to appear all future hearings, of course, and not violate any condition of the court.
Did the AG want to respond to the motion?
Your Honor, he is an out-of-state resident, so we do want some money put up front here on, the total amount that the court feels is reasonable up to the court. We We did have to extradite him. The taxpayers are out $2,400 already. We don't want to have to repeat that process and throw more money at it. So it's important that there be some skin in the game on his part, which is in the form of cash. If the court does elect to establish a lower bond, something that he can meet, we would want a wage assignment entered so that we can get some child support payments made to the children. And in addition, because of the history of domestic violence, there will be no contact.
You said his employer is here.
Yes, Your Honor.
Who's the employer? You stand, sir? What's your name?
My name is Andrew Richardson.
Andrew Richardson.
Yes, ma'am.
What state do you live in?
I live in Ohio.
You live in Ohio. He works for you in Ohio?
Yes,
Okay.
he's been working for me since about June this year.
You have a company?
Yes, it's called Andrew's Painting Company.
Okay. How do you pay him?
I've been paid cash.
How are we gonna get a wage assignment if you pay him cash?
We had discussed him actually going on payroll. He has only been with me for a couple months and I didn't know how long he would be staying. But
So you pay him under the table?
he's considered a subcontractor. If he stays on for the time, I can put him on the payroll and have him as a W-2. But for the time being, he's a subcontractor. Cash payments $10.99.
Okay. And those are the parents, so that's not, who these, you're the father?
A son and the father.
Okay, you're the father, Mr. Mondojano Senior?
Yeah.
It's not your child support order,
No.
right? Okay, and where do you live? You live in Michigan?
No, I live in Ohio.
You live in Ohio as well?
They're all fluent, Your Honor.
You flew in from Ohio? What part of Ohio?
Well, she flew in from Texas.
Okay, but he lives in Ohio.
Yes,
What part of Ohio?
Cincinnati.
Oh, okay, so you came up from Cincinnati, Ohio, so, okay.
Your Honor, I provided the name of the employer and the letter that was.
Where
with the
does
address
your,
and everything
where does your client live?
In Texas.
But he works in Ohio?
Well, he's Texas and Ohio, so the jobs he has, like lives in Texas, but he does work in Ohio and Texas, so.
Where does he sleep when he's in Ohio? Oh, you stay with your dad. Got it. Makes sense. Okay, it's all coming together now. Okay. I'm not really comfortable with your employment situation being something that would provide us the opportunity for a wage assignment because you're being paid cash.
He was being paid cash up until this release upon the condition that the child support was developed as paycheck.
You need to come closer because our mic can't pick up what you're
I'm
saying.
sorry. What I'm saying is up until this point, he has been a 1099 employee, but if he's released on the condition, he must make payments on child support pending the next court date. I would put him through a payroll service and have taxes and child support deducted from his paycheck, starting with his very first paycheck.
And where would your client be living if he's released?
Honestly.
I believe with his father.
What's that address? Because you didn't provide that to the court.
2 Beckford Drive.
Spell that?
ECK-FORD.
Cincinnati?
Yes.
What's the zip?
45218.
What's your number? Telephone number, sir?
Me?
Junior.
614-980-2050.
Okay, I'll reduce the bond and amend it to 5,000. It must be in cash and it must be in your name. There must be a wage assignment for you to pay child support while you're released. All your other bond conditions will continue. You need to report to all of your court dates. And you need to make sure you're not engaging in any assaultive or threatening behavior. You're not carrying a firearm or any other dangerous weapon, you would have to report to pretrial services within 48 hours of your release. If that's over at the circuit court, you'll get that, you can get that information and how to report to them from the jail, okay?
No contact with Vivian Burns.
A no contact order will be granted. You're not to have contact directly or indirectly with Ms. Savion Burns. Sounds like she blocked you anyway, so that might not be a problem, but indirect contact would mean you can't ask anyone else to contact her on your behalf, okay?
Yes.
And if you have concerns about how that impacts your ability to make contact with your children, if that's a concern that you have, you can handle that over at the family court, okay?
Yes.
You have any questions?
No, Your Honor.
Okay, any additional?
No,
Master?
thank you, Your Honor. You're very thoughtful process.
Thank you so much, Your Honor. I
Thank
appreciate
you,
it.
thank you, you're all set, and here are your incidents.
Your Honor, sorry, is it so, it's a cash fund in my client's name, in Jose's name that?
It must be in Junior's name, correct?
Okay.
On the record in the matter of the people of the state of Michigan versus Johnny come late Barney, file number 23-03790. Mr. Barney, why are you late? It's your wife's fault. You should have brought her in here and
She was
threw her under the bus.
She never went to work.
Your alarm's on your phone, so it went off, and she turned it off, and you rolled over and went back to sleep.
I rolled over and looked at her, and she had a ugly face, and I just. She was gone, so I jumped up and took her because I already knew her body and
Listen, your attorney truly believes in you because she knew you were coming. She would not leave.
Yep.
She was standing her ground on the bench warrant. She said, no, he's gonna be here, Your Honor. So I'm gonna go ahead and reset this. I had to release the officers because they were here on time, ready to go. And it's 11:30 and they need to get back outside and keep us safe before the storm. So with that being said, I'm going to reset your matter. I'm gonna have to find good cause to go beyond your timeline. So you had the right to have your exam within 21 days of the date that you're arraigned, but because you were late, we can't have it today. So I'll find good cause to reset it and get you a new date, okay? March 8th at 8:30. March 8th at 8:30. Do you have any questions?
Okay.
Okay, there's that. So we'll get you a new court date and you'll be all set. Your bond will continue. Any additional matters for the record?
Nothing political, Your Honor. Nothing for the defense, Your Honor, just need him to wait for his paperwork.
That's correct.
All right, thank you, Your Honor.
Why did I think, why did
No, Your Honor.
Is Potter here?
No, I was able to speak with him this morning. He just got out of the hospital yesterday. And the individuals who take care of him, he had some serious medical issues,
Right.
did not come to pick him up.
We've had that issue with them before.
I am aware. I do also know that witnesses did not appear either, which I know would be relevant to decisions on bench warrants and other things.
This is officer witnesses?
Officer.
No, this is home invasion.
Yes, Your Honor. Officer Erica Halfman was subpoenaed, and then we also had two lay witnesses, the victim, Rebecca Dallahan, and a witness, just another witness, Rodney Force. As far as I was able to find out, they were subpoenaed, but I did not.
Okay, counsel, how do you want to proceed?
I would be asking that, given both parties do not have the people necessary to proceed today, that we adjourn this matter and set it for prelim on another later date.
I would ask, because the prosecutor's witnesses did not appear, I would ask that the court excuse my client's non-appearance due to him just getting out of the hospital and dismiss the case at this time.
The motion to dismiss will be granted because I just don't foresee how it would be meaningful to have these caretakers who've neglected to bring him twice. This will probably be the third time, actually. I don't see how they won't do it again. So the prosecutor obviously has the right to reissue the case, and you can remind that or let your client know that, but I'll grant the knowledge under these circumstances. And